I trust that we would confine today's proceedings to the particular matter of concern which has been exercising many public minds in the last few days. Let me begin by saying that I issued a statement by way of my office a couple of nights ago indicating that today I would respond to the development with respect to the intention of the Chief Justice to withdraw from his duties for a protracted period of time under the understanding that he was going on sabbatical leave. Permit me to say that I became Prime Minister of Trinidad and Tobago on the 9th of September by swearing to an oath of office to conduct the business of the executive and the affairs of this country assigned to the Prime Minister and the executive that she leads, to conduct that affair without fear or favor, without malice or ill will. And in so doing, I am required to observe the tenets and the perimeter of the authority that goes with that executive. It's against that background that I saw in my office on the morning of the 7th of March a piece of correspondence from the President, His Excellency the President, requesting of me, as part of the consultation that is required under the Constitution, my position with respect to the appointment of a judge to fill the vacancy that existed on that day or before, arising out of the Honorable Chief Justice vacating his position to go on a period of sabbatical leave that extended for very many months. I must say that I was taken aback by this because I, as Prime Minister, know of no authority which would have created this facility. His Excellency's letter to me was accompanied by two pieces of correspondence that passed between himself and the Chief Justice. One was an application for this leave by the Chief Justice, and the other was a letter of thanks to His Excellency the President for approving this leave. It is my understanding as Prime Minister of Trinidad and Tobago that the terms and conditions of all office holders, particularly the higher judiciary, who are paid by the Exchequer, require that such authority for payments and holding of office commensurately lies with the Cabinet of Trinidad and Tobago. The request for this leave began in reference to the Salaries Review Commission report. This is the 98th report, which was laid in the Parliament. I was a member of Parliament when this report was laid, And as a matter of fact, I took part in the debate. The laying of that report, or any similar report from the SRC, is a requirement of law. It matters not what the cabinet thinks of the contents or the recommendations, any position advanced by the SRC. The law requires that that report be laid in the parliament. However, the report, as is normal, carries with it specific recommendations, notwithstanding what may be contained in the deliberations leading up to those recommendations. And the 98th report is no different. It made reference in what I may call the preamble to a position advanced to the Parliament to the SRC by the judiciary for a new facility called sabbatical leave, which judges or the spokespersons who spoke to the SRC thought is something that could improve their circumstance, because the terms and conditions of the judiciary can only be improved. It cannot be decreased or diminished in any way. It can only be improved. So any change is for an improvement. That's what the law allows. So here a proposal was put to improve, by way of this change, to add this new facility, which is not without significant cost to taxpayers and also significant effect on the operations of the judiciary. And while one observes the role of the executive and not wanting to trample on the independence of the judiciary, the executive always has to keep an eye on the cost to the taxpayer of all governmental activity, even when it falls to the Parliament or the judiciary to exercise that incurring of that cost. So this sabbatical was mentioned in principle, the words of the SRC, in principle. And it was circumscribed by its length, by way of recommendation of 6 months, and to access it by persons who were there on the job for 7 years. So the recommendation in the preamble refers to this 6 months and the 7-year period to qualify. And then the document goes on to make specific recommendations of the changes that the SRC in its 90th report put to the Parliament for consideration by route of the Cabinet. And to the best of my understanding and the reading of that document and the advice that I have is that in the recommendation, there is no provision advanced by the SRC for a sabbatical as a change in the consideration for the terms and conditions of members of the higher judiciary. That being so, it is the position of the Cabinet that there is no condition which would allow the Chief Justice to go on sabbatical, for whatever reason. There's no authority for that. And therefore, had the Chief Justice proceeded, there would have been consequences of one kind or another. However, last night it was brought to my attention that a public document existed which purports to have come from the Chief Justice. I have seen no signed letter. I saw a media release, and in today's world where all kinds of things can appear, I take it that it is reasonable to assume that that document, which is a media release coming from the office, from the judiciary, is authentic, and if it is so, a new problem arises. I have this morning written to His Excellency the President, who had replied to me, expressing a contrary view to what I have just outlined, indicating that the Chief Justice has a legitimate expectation to access sabbatical leave, and surprisingly, in answer to my question as to the authority for such leave and its implications for the taxpayer and the dispensing of judicial services, His Excellency the President quoted to me his authority as the said 98 report of the Salaries Review Commission. This matter was discussed by the Cabinet this morning, and I dare say, as head of the Cabinet, notwithstanding any other opinion, I reject that position. It is my view that the President has no authority to arrogate unto himself, nor does the Chief Justice have the authority to change the terms of engagement of any member of the judiciary, particularly the Chief Justice. The authority for changing the terms of officers, that authority lies with the executive. And as head of the executive, I will guard that very zealously. I know that there are different opinions, and one can get as many opinions as there are lawyers. But until such time as the ultimate authority rules, it is the position of the government that I hold. It is my own personal position, because there are nuances where my personal position comes into play. But it is the position of this government that this development, wholly unnecessary as it is, disturbing as it is, needs to be dealt with frontally and decisively. And it's against that background that I have today instructed the Attorney General to take all legal steps to proceed to have the relevant authority, namely the courts, clarify in the face of contrary opinion whether in fact there is in existence a legitimate expectation on the part of any person in the judiciary to access sabbatical leave. And I do this against the background that the document which purports to have come from the Chief Justice last night, indicating a change of the nature of the leave, that document makes reference to the office holder reserving his option to access sabbatical leave. In furtherance and in desire of having it be made abundantly clear whether this situation exists to be accessed by him or others in the judiciary, that this matter needs to be clarified by the court. I've taken the opportunity to volunteer my advice to His Excellency this morning, and by extension to the Chief Justice, that in this new position of vacation leave, that both these officers take note of the written conditions laid down in law insofar as they govern the use and access of leave by members of the Chief Justice, members of the judiciary, including the named Chief Justice. Because you see, it's interesting that this should be a difficulty that I'm having to deal with now, as if I didn't have enough difficulties to deal with. This is one of the few instances where leave is spelled out in law, how it should apply and how it should not apply. So the government finds it difficult to understand why these confused situations are developing and demanding our attention. I have heard members of the national community, some of whom hold themselves up as leaders, leading us down a path of interpretation that the actions of the government, and namely the action of the Prime Minister in this matter, has to do with where I come from, my genealogy, and other things. I want to give the national community the assurance that the only consideration that I will have in dealing with this and any similar matter is in the context of the oath of office which I have taken.